Welcome to today's webcast, brought to you by VMware in partnership with the Independent Oracle Users Group. I'm Stephen Faig, Business Development Manager at Unisphere Research in Database Trends and Applications. I will be the host for today's broadcast. Our presentation today is titled Straight Talk on Oracle on VMware Licensing. Before we get started, I want to explain how you can be a part of this broadcast. There will be a question and answer session. If you have a question during the presentations, just type it into the question box provided below and click on the Submit button. We will try to get to as many questions as possible, but if your question has not been selected during the show, you will receive an email response to it. Plus, one lucky viewer today will win a $100 American Express gift card. The winner will be announced at the end of the event, so stay tuned to see if you've won. Now, to introduce our speakers for today, Don Sullivan, Oracle Certified Master, VMware vExpert, VMW CTO Ambassador. Dave Welch, CTO and Chief Evangelist, House of Brick Technologies. Daniel Hesselink, Managing Partner at License Consulting, and Dan Young, Chief Data Architect at Indiana University. For more information on our speakers today, you can click on the speakers icon at the bottom of your console. Now I'm going to pass the event over to Don Sullivan.
Thank you much, Stephen. And I want to thank all of the audience members for taking time out from the onset of the NCAA tournament to listen to our discussion here. Myself and Dave Welsh and Daniel Hesselink and Dan Young, we're going to be presenting here, certainly can be considered the Final Four on this subject. So, again, I'm glad you're all here, and we're going to spend some time on this very important subject. And specifically, I want to thank House of Brick and License Consulting, Database Trends, and the IUG for really making this possible. Very important point, VMware, House of Brick, License Consulting, IUG, all agree that VMware and Oracle customers should fully satisfy their individual licensing obligations when using VMware and/or Oracle software. This session, again, will be available through Database Trends website on replay in perpetuity. VMware acknowledges that all licensing agreements between Oracle customers and Oracle it's completely between Oracle and Oracle customers, and we're commenting here on what we understand about the public documents and so on. A couple of really important points to sort of start off the real substance of the discussion. We know that the Oracle licensing agreement itself is VMware agnostic. And we know the only information relevant to discussion whatsoever comes directly from the contract between Oracle and the Oracle customer. There's all kinds of other superfluous information, peripheral information, discussions, webinars, blogs, and so on. None of that really has any relevance unless it's directly related or it's directly within the contract. And from a VMware perspective, the definitive document, which constitutes the VMware position on everything we're discussing here, is listed below, and we have an updated version for 2015. It was originally a 2011 document. There are some small but significant changes. So with that, I'm going to hand it back to Stephen, and we'll listen to Dave Welsh.
Thank you very much, Don. Passing it over to Dave Welch, CTO and Chief Evangelist of House of Brick Technologies.
Thanks, Stephen. I'm Dave Welch with House of Brick Technologies. I've been active in House of Brick's Oracle License Assessment business line since our company's inception in 1998. We lead the world in Oracle on VMware implementations and have been active in Oracle on VMware License Consulting since 2006. Here's a list of public-facing Oracle contract documents I found just inside a few hours of searching. You can validate our Oracle contract conclusions by searching these documents, which span years, or by searching your own contracts. This is a list. This slide is going to be a build of a list of non-contractual assertions made by Oracle representatives regarding Oracle on VMware licensing. Number one, Oracle's been telling everyone since at least 2002 that is, that VMware is a form of soft partitioning, and that you can't soft partition a single physical server to limit your license liability to a subset of that server's cores. Non-contractual assertion number two. Oracle's been telling everyone for about the same amount of time that all physical hosts in a VMware cluster must be licensed for Oracle, not just a subset of hosts where the Oracle programs are installed and or running. Non-contractual assertion number 3. More recently, we've been exposed to Oracle reps implying that soft partitioning may be a cluster-level concept. Assertion number 4. The so-called 10-day rule allows you to run Oracle programs on an unlicensed server for up to 10 cumulative days in a calendar year. Fairly recently, we have heard Oracle reps claim that the 10-day rule is moot on VMware, and therefore the free 10 days are not allowed. Assertion number 5. vSphere 5.1 allows live migration between clusters managed by the same vCenter. Oracle reps have claimed that as of vSphere 5.1, all vSphere hosts attached to the same storage array or NAS must be licensed. And non-contractual assertion number 6. vSphere 6 allows live migration anywhere in the vSphere enterprise. Oracle reps have claimed that as of vSphere 6, all vSphere hosts in the enterprise must be licensed. My VMware corporate colleagues affectionately refer to this as Galaxy licensing. Oracle has no contractual merit or teeth for any of these claims. Accordingly, I am about to demonstrate that the Oracle contract is in fact agnostic to VMware in every way. So, who interprets the contract? Who's authorized to interpret your Oracle contract? At House of Brick, we have taken particular interest in Oracle's lawsuit against Rimini Street for conversion of intellectual property. As much as I would love to comment on the suit here, that would be a distraction, but suffice it to say, House of Brick is assertive in defending the contractual rights of any party on any given issue. You may have been told that Oracle License Management Services is the only entity authorized to interpret the contract. That's Oracle's business should it enforce that inside its own ranks. But note these 4 interesting pieces of case law that U.S. District Court of Nevada Judge Hicks referenced in his February 2014 finding in the first phase of this litigation. It would appear that when plain contractual language is evaluated, the contract speaks for itself. There's empowerment in understanding that for Oracle licensees. Oracle's processor-based licensing metric is, well, it's processor-based. If you've taken in this webinar, I suggest you memorize this sentence in the contract, regardless of your work role, and I quote, "Processors shall be defined as all processors where the Oracle programs are installed and or running." End of quote. That's it. Your license is not cluster-based, it's not SAN or NAS-based, it's not even server-based. You'll find the same material identically statement in your contract, whether it was executed in 1993 or 2015. Installed is past tense. Running is current tense. As such, there is nothing prospective in your Oracle contract language. Oracle has a handful of public-facing policy documents that comment on Oracle licensing. Let's use the contract to determine which of those policy documents are contractual. I happen to be using the December 2010 public-facing Oracle License and Services Agreement for this exercise, but I could have used any Oracle contract paper post-dating August of 2008 to do this. In the contract's technical support section, we find the, quote, technical support policies incorporated into this agreement, unquote, end of quote, by direct reference. Then there's the URL where the technical support policies are found. In the contract's licensing and definitions rules section for all contracts, August 2008 and newer, we find the processor core factor table also integrated into the agreement by direct reference. The URL shows where the table is found on Oracle's website. There are no other license policy documents integrated into the contract by direct reference. This is the contract's entire agreement clause. I quote, "You agree that this agreement and the information which is incorporated into this agreement by written reference, together with the applicable ordering document, are the complete agreement for the programs and or services ordered by you, and that this agreement supersedes all prior or contemporaneous agreements or representations, written or oral, regarding such programs and or services. So, having read and scanned the entire contract for any external policy document references, and with the entire agreement clause in mind, let's determine the contractual merit of each of Oracle's 7 licensing policy documents. The Software Investment Guide, it is not contractual. Its non-contractual status doesn't matter as there's nothing in it that contradicts the contract other than one phrase that I'll show you in a moment. The Licensing Data Recovery Environments document, not contractual. Its non-contractual status also doesn't matter as everything in it is quoted directly out of the contract. The Technical Support Policy document, it is contractual, as we've demonstrated previously. The Processor Core Factor Table, it is contractual, as we've demonstrated previously. This policy grants discounts to multi-core processors, meaning one purchase processor could license more than one core depending on the processor model. The Oracle Partitioning Policy document is non-contractual. This document is locked out by the entire agreement clause. The Cloud Licensing Policy document. The contract does not make this document contractual. This document's been in place for about 5 years now. It allows Amazon, AWS, EC2, and more recently Microsoft Azure customers licensing leeway not specified in the contract. Although a non-contractual document, the courts would call what Oracle has done with this an implied license. It's important to note a licensor can grant extra contractual privileges with an implied license, but contractual privileges cannot be stripped away by extra contractual restrictions. And finally, the Hosting Policy document is non-contractual. You'll find this footer in each of the non-contractual policy documents. I quote, "This document is for educational purposes only and provides guidelines regarding Oracle's policies. It may not be incorporated into any contract," and I close the quote. That's interesting, but understand that footer is not what makes those policy documents non-contractual. Those documents are non-contractual because they are excluded by the contract's entire agreement clause. Here we have a vSphere cluster consisting of 4 physical vSphere hosts. We have Oracle installed and or running on hosts 1 and 2, and non-Oracle workloads running on hosts 3 and 4. As such, only hosts 1 and 2 need to be covered by Oracle licensing. The diagram on the left shows a live migration of an Oracle instance from host 1 to host 2. The only way the contract mandates cluster-based licensing is with the Database 10G and newer Standard Edition Real Application Clusters bundle. In that bundle, the maximum capacity of the physical cluster cannot exceed 4 processor sockets. We thought you would enjoy this. One of my partners, David Woodard, came up with this metaphor for Oracle's non-contractual assertions. The driver exiting the parking lot says, $1 million to park my car. Oracle replies, we had to charge you for every spot since you could have parked anywhere.
That's amazing, Dave. And in San Francisco, it might be more.
Oh, good one, Don. So search the contract document for the word cluster to see if you really do have to pay Oracle for every parking stall. You'll find a MySQL cluster reference. You'll also find a recent tightening wherein the unlicensed so-called 10-day rule node must share a cluster with a license-protected node. You'll also find the Database 10G Standard Edition Rack Bundle Maximum Cluster Socket Capacity I mentioned a moment ago. And depending on the version of your contract, you may also find the statement that WebLogic Server SE doesn't include WebLogic Server clustering. Your search will produce nothing that will obligate you to full cluster licensing where you have installed and or running Oracle on just a subset of the cluster's hosts. And while you're at it, consider searching the contract also for the words virtual or VMware or the phrase shared storage or any other terms you can think of related to Oracle's licensing assertions that are specific to VMware. You will find nothing. This page out of the Software Investment Guide perfectly illustrates how to safely implement subcluster licensing. What follows is not needed for contract compliance under normal operations. However, to further protect yourself operationally against human error, consider LUN zoning, also known as LUN masking. In other words, control access to the vSphere data store at the fiber/network level. NFS-based arrays normally have the ability to be configured at the array level to restrict access to certain hosts. At even a lower level, any Unix or Linux server can control access via the etc exports file. See House of Bricks October 3rd, 2014 blog entry for more information on this topic. The diagram shows a shared storage LUN containing WebLogic executables that is accessible only by the 8 hosts in the cluster running WebLogic. Similarly, a shared storage LUN containing Tuxedo executables is accessible only by the 6 hosts in the cluster. The only thing we've noticed in the Software Investment Guide that's in collision with the contract is this page's header in the upper right-hand corner, non-virtualized environment. But as we have demonstrated, the contract is agnostic to VMware. It is indeed your privilege to restrict and manage your Oracle license on VMware in the manner shown. Here we have the Oracle partitioning policy document, a quote from it. Oracle's partitioning policy document has been published under various names since 2002. The partitioning policy document's first sentence makes clear that soft partitioning, as Oracle defines it, is a server-level concept. It has to do with limiting the licensing liability to a subset of a single physical server's cores. You may have also been told by Oracle representatives that soft partitioning is a cluster-level concept, and that is incorrect. More on the partitioning policy document. It has always maintained soft partitioning is not allowed to restrict licensing to a subset of a server's cores in a VMware environment, and that VMware is a form of soft partitioning. But alas, you can ignore this restriction because, as I have demonstrated earlier, the partitioning policy document is rendered non-contractual by the entire agreement clause. This reminds me of a bank teller I watched in Italy back in the 70s. That's before the dawn of time for a lot of the attendees. I was waiting in line for him. He was rapidly flipping through the banknotes a merchant had handed him for deposit. Suddenly the teller stopped, removed a note. He reversed a note or two, then he pulled a note out. As he held it up to the light, he said, "E bello mai falso." It's beautiful, but it's false. Similarly, Oracle's very well-written, clear-to-understand partitioning policy document is of no import to Oracle on VMware licensees. Although soft partitioning using VMware is your contractual right, House of Brick details technical risks associated with its use in our September 17, 2014 blog entry. In our Oracle internal audit business line and Oracle audit defense practice, we spend a lot of time guiding our customers' legal teams. Many of our customers do their own case law searches to see how many times the world's largest relational database vendor has filed a legal challenge on any of its non-contractual VMware-specific licensing assertions. This slide lists the result of their case law searches to date. I have no doubt that if Oracle believed it had a claim with any merit it could take to the courtroom on these issues, this slide would have looked quite differently years ago. A prominent analyst house that will remain unnamed in this webinar recently published a paper stating virtualization on VMware increases your risk of an Oracle audit. Okay. What I take issue with is the paper's logic and recommendations. As a sample of my issues with the paper, it recommends that you have your reseller or Oracle itself specify the required licensing for your environment. Then drive for an amendment so as to make either the reseller or Oracle responsible for their specification. The flaws of this advice should be obvious. Oracle may be all too happy for you to fix your architecture without Oracle licensing in mind and then come along after the fact and price the licensing for your environment. It's also probable that Oracle will decline to amend in a way that the reseller is operationally bound in your contract. And I further add that I see no benefit at all on driving for amendments to specify contractual privileges that you already enjoy. Watch for my blog entry titled Virtualizations and Audit Risk paper for a full analysis of that. So here's my contact information and a copyright notice slide. And then, Stephen, I'll hand it over to you at this point.
Thank you very much, Dave. At this point in time, we're going to move on to our next speaker, Daniel Hesselink, Managing Partner at License Consulting.
Hi, everyone. I'm Daniel Hesselink, Managing Partner from License Consulting. The reason why I've been asked to participate is that we're highly specialized in Oracle licensing and provide our clients with different services with regard to Oracle compliance strategies, including data analysis, assisting and resolving the outcomes of both internal and vendor audits, and many other things. Therefore, virtualization is one of the many subjects we deal with on a daily basis. It is my goal to enable you today to understand the following issues. Indeed, the white papers do not make sense, that ignoring Oracle's position alone is not good enough, but rather a liability, and that you can benefit from virtualizing Oracle in the very same way from virtualizing other software. To illustrate what Oracle is doing for a long time already, I'm showing you a cluster of ESX hosts. 3 of them are running, at least to some extent, Oracle Database Enterprise Edition software. 1 of them is hosting a database with some Enterprise Edition features. While arguing that you must pay for all of them and for all the features, it's a far-fetched for some already. But Oracle would even request you to license also those servers and their processes which are not running Oracle at all. In this case, the cost would be $8.8 million. Surely, many clients would create a separate cluster with only 3 hosts to cut the cost in half from 8.8 to 4.4 million. That's exactly what happened here. The client now has 3 servers running the Oracle software. Other than that, the client has 2 other clusters within the same vCenter, and they are for running competing software, Microsoft SQL and Db2. So there is no Oracle installation at all, and no processes are running any Oracle programs. Now, strangely enough, instead of cutting the cost to $4.4 million, Oracle would now ask you to pay $22 million only because you upgraded your vSphere Center. Now, if your Oracle counterpart is in a good mood, he or she may propose to create a new vCenter control domain with its own data store to prevent the $22 million from materializing. Now, if you would agree to that so-called solution, just wait what happens once vSphere 6 comes out, and you can move VMs between data stores and control domains. Chances are you'll probably have to license your entire data center if you read the Oracle white papers. So this may all sound very ridiculous, but is it really true what David and I are telling you here? Maybe we should ask a lawyer. As you can see in her statement about this, I hope you have no further doubt on this. Oracle's allegations are too hilarious to take serious, and there's no reason why you should not dismiss them altogether. They are self-invented, they have no contractual basis, and they're unfit for concluding contractual compliance or incompliance. A processor doesn't change all of a sudden from virtualizing. It's still the same hardware, it's still the same software, it's still the same processes that will be running the Oracle programs. Now, putting it in front of you so black and white, you might start thinking that the virtualization discussion is the easiest of all discussions. In some way it is, but it really isn't. In the hundreds of cases we've been involved with, the incompliance risk and the issues were largely on other areas than virtualization. Clients do not see these other issues coming, and therefore they're often like lying on their backs while discussing the virtualization problem. Let me illustrate this with 2 very practical examples. We had a client who was so small, we couldn't really believe that they had been audited by Oracle. They have one database, one server with an annual support spend of less than $1,000. Oracle, however, managed to put a claim on them for almost $300,000. Why? Because they had, within their Standard Edition 1 feature, accessed some of the Enterprise Edition functionality, which, according to Oracle's own documents, shouldn't be accessible to begin with. However, with this opportunity and according sales pipeline at Oracle's end, it can be very frustrating to make such a discussion go away. In this case, the client even had to hire an expensive lawyer for resolving this claim, and it took a long time to make Oracle go away. And trust me, nobody saw this coming. You may think that this example is excessive. I think the size of the customer is excessive, but the discussion really isn't. We encounter this on a very regular basis. Now, another much larger customer with many more databases and about $1 million of annual support spend, they had also virtualized large portions of their estate. They realized that Oracle's white papers wouldn't stick anyway, so they did it sort of in the best effort. Before Oracle came in for an audit, we came in to analyze all the millions of rows of audit data and demonstrated why and where Oracle would claim $15 million worth of software licenses. Now, because we do this on, in large environments, we were able to do that work within a week and explain the situation to them. As you can see in the bottom line, the virtualization discussion was rather small, but the rest was not small. But the reality is, if you have a problem of $3.7 million that you don't agree with, and you have another problem of more than $10 million that you cannot hide from, you're in a really bad negotiation position. Now, the good news for this client was that because they had virtualized already, they could very quickly change their deployment and license allocation in accordance with our instructions. And when Oracle did come in to audit them, they were unable to substantiate any license deficit. So I guess what my message is, you shouldn't bring a knife to a gunfight. You should be willing and able to bet your paycheck that you are not at risk before isolating the virtualization discussion towards Oracle. Doing all that is really worth your while in many ways, and not just to defend yourself from Oracle. Also for us to do a proper job, it's really mandatory work. So ideally, we would make that forensic analysis, regardless if Oracle is involved or not, and regardless if you have already virtualized or not. The outcome, however, it will enable you to reduce or eliminate any unforeseen risk which may be held against you later or now, sometimes years later, but it also illustrates which internal processes and procedures could lead to compliance risks. And with our reporting, you can prevent them from reoccurring again. Now, once we understand the actual necessary deployment, we'll work with your IT teams to make a fine-grained virtualization strategy and allocate proper licenses to the ring-fenced environments. This helps you to make informed decisions about the different scenarios we will typically come up with. We'll do this to the level of detail where you know the CPU utilization per cluster, per ring-fenced environment, per license really, and all the cost involved. And then, companies can easily make an informed decision about the strategy going forward. Because we work so closely and hands-on with our customers' team, they will really become able to keep a better eye on the deployment, much better than they were able to do before. And it allows them to prevent drastic compliance issues altogether. Typically, we encourage customers, if they virtualize on VMware, to use the orchestration tools to enable that specific VM templates can only launch within specific ring-fenced environments. And in addition to that, we'll frequently check if the actual use is still within the intended profile. All that really pays off because, as I said, the devil is in the details, and we are really keen on those details. Now I will talk a little bit about the sort of situations that we get into and why we would get involved in communicating with Oracle. Now, depending on every project and the client and the situation at hand, we may or may not have a direct contact with Oracle. So we work either inside of Oracle or in the background. But the goal of our work is to really help customers understand how to manage that relationship, how to manage that vendor, to efficiently ensure they're not exposing themselves by simply answering all the questions that Oracle is asking, thereby weakening their own position. Doing this in a structured way, you'll find that Oracle is quite predictive. This is very helpful for making good progress, provided that everyone on the client's team is really aligned with the strategy we have. I cannot stress enough how important it is to do this the right way, simply because Oracle will outplay you otherwise if you don't take this serious. I mean, they do this all the time. They have a power map about all your individual team members, and they know exactly how to reach their end goal by influencing all the different players in your team. By now, you're probably really curious how we would discuss with virtualization, all the aspects of virtualization with Oracle's auditing teams. It's really simple, because we don't. And let me show you why that is by introducing Oracle's auditing teams. On first glance, you think it's almost impossible that this great proposition comes free of charge. In fact, opening and reading an audit announcement letter from LMS, it almost feels like winning the lottery. But these are random LinkedIn profiles from different LMS team members. Fill in the gaps as you read the yellow markings. A couple of years ago, we blogged about similar LinkedIn profiles as these ones, and they were set to a global default within 48 hours, and I'm sure that will happen within the next 48 hours. And here is another one. Now, I want to emphasize that their work is the responsibility of their manager. This is nothing personal against them. They're good people. You have to be aware of the powers within Oracle to really grasp this storyline. This is almost my last slide, and it's really important. Oracle's team is a lot smaller, it's a lot more compact, and they play this game all the time. For anyone having a white paper/virtualization discussion with Oracle, it's really important to know who's who and what makes them tick. Now, I guess you could call this Oracle's influencers map when it comes to discussing white papers. The three at the bottom are salespeople. If any of them would read the utmost detailed arguments about your license assignment in virtualized environments, other than Oracle VM, of course, if they would acknowledge they're correct, then the next day they will be probably working at Oracle's coffee bar, if they're lucky. However, the two on the top are the really important players. That is because they're the ones who countersigned the contract, where you have agreed with Oracle what a processor is. Also the ones carrying authorized signatures when it comes to legal documents. Lastly, your agreement typically states that in the event of a dispute, you should contact Oracle Legal. And there is really no reason to talk to anyone else but Oracle Legal once somebody claims you owe them money because of a white paper Oracle invented. Now, if you would continue discussing this with revenue-dependent people, they would typically end up positioning Oracle Legal as a threat towards you. And that is bad motivation for our troops at the client side. And that, ladies and gentlemen, is the real reason why we strongly advise not to discuss white papers and policies with Oracle LMS. So now let's virtualize. The one who tends to be in the awkward position is always the customer, but it shouldn't be. It should be Oracle. There is no problem at all except one that Oracle has self-invented. All major software publishers, including IBM and Microsoft, have clear contractual restrictions and provisions with regard to virtualization. Oracle has, to be exact, none. Users of Oracle VM, where Oracle does allow fair licensing practices, have exactly the same contracts and definitions in place as all the Citrix users, Xen users, VMware users, and Hyper-V users. So there is no reason whatsoever why you could possibly be treated any different. Your contracts are agnostic towards virtualization, and Oracle cannot one-sidedly change that. So you're in a safe place, but you need to do your homework properly. Be willing to bet your paycheck and then play the game. Play it wisely. In the end, agreeing to disagree with Oracle may very well be a great place to be in. And that's the end of my slides.
Thank you very much, Daniel. At this point, we're going to go back to Don Sullivan.
Thank you, Stephen. Lots of questions coming in. Thank you, audience, for participating to the extent that you have. The first question that I would like to pose is to Dave Welsh. Dave, can you please clarify what non-contractual means, and then also how the contract differs and it needs to be positioned in the discussions versus policies? So I think there's some misunderstanding out there on policies versus contract, and then also what contractual actually means as opposed to non-contractual.
When I say non-contractual assertion, that means that somebody is trying to obligate you in a way that the contract doesn't support. For example, if I am taxes, for example, I believe in paying every penny that I owe, but any money that I should give to the government beyond my statutory obligation with taxes, that's non-statutory, non-contractual, it's a donation. So at all times in your interaction with Oracle, the contract rules. Any of these policy documents, regardless of how long they've been out there, how clear they are, how pretty they might be, if they are not referenced by the contract, they are excluded from the contract by the entire agreement clause, and therefore they are non-contractual assertions, and in some cases they actually collide with the contract. So that's, hopefully I've clarified it with that, Don.
Yeah, thanks, Dave. So, Dan Young, I'd like to bring you into the discussion here, and congratulations on your new role, and I'll have a slide later talking about the VMware Special Interest Group inside of IUG, but, and congratulations as the president of that newly formed Special Interest Group. But as the Director of Database Services at a massive public university, how would you describe your experience managing Oracle licensing?
Well, I would go back to something that I think Dave mentioned earlier at the beginning, and he said to really know your license and to understand the terms that are there within that. I have spent a great deal of time, and I have to thank one of my colleagues who was actually able to dig up a paper copy of some of our original documentation, but, just really sort through that and really make sense of it, to understand what it means for you. And Dave is exactly right on with respect to the fact that what's in the contract is really what matters. And so I think being able to educate yourself as to the terms of your agreements, and even if that means going back in history and trying to, even ask Oracle and say, hey, what documents do you have on us? Can you even help us understand what our licensing model looks like? Is
but have you yourself, as is your experience in Indiana, have you had any difficulties with it overall, do you think?
No, not in particular. Speaking specifically of VMware, there are many things that are sort of out there in terms of sort of the myths that sort of surround virtualization, but we've never really had any particular contractual issues there, but also we've never had any support items as well. So one of the things you'll often hear is, well, Oracle wants to support you, and that's just not the case. When we open service requests, we get response, and it doesn't matter to us whether it's on a physical infrastructure or virtual infrastructure. It's all been really a very positive experience.
Thanks, Dan. So Daniel Hesselink, I'm going to aggregate a bunch of questions here that are coming across right now. In your experience, is there a substantial savings and is there a substantially greater effectiveness in creating architectures for customers that are wise enough, shall I say, to engage in consulting specifically in the license arena?
Yeah. I mean, not only with regard to Oracle, also to Microsoft. The more details you dig out about any given environment, the more opportunities you find. It's like a gold mine, virtualization, I think, for cutting costs in your license environment. The real question is which concessions would the IT team want to make in order to save the cost. So we have to create different scenarios, cost them, and then make a good decision.
Let me extend that question, though, to something more specific. In terms of Oracle, and I don't want you to reveal anything that you really shouldn't be, but is there any particular example, other than case studies you gave, in which you can just cite a massive amount of savings that occurred, either because of the defense of an audit or just simply the re-examination of the overall architecture that you've worked with?
Yeah. It's a lot about interpretation. It's about interpretation of an architecture. What is considered as disaster recovery, for example. What can be discussed as a failover, and Oracle's interpretation is, of course, always in their benefit. But if you get down to the details, they will also acknowledge, practically. How much is this example worth? What you're doing in terms of money. So the more details you know, the more likely it is that Oracle will maybe possibly in some situations want the license quantities. But I mean, if each license will only cost $1, nobody's complaining.
So Dave Wells, let me follow up with you in that. Everything we've talked about here, how does it apply, or is there more leverage that you have in regards to licensing for non-production environments such as test dev or even DR?
Well, I'll tell you, for scale environments at all, what I'm about to say may not apply to the small to medium business market, but Nirvana is a 100% processor-based licensing metric on VMware, Oracle on VMware. Because the noisy neighbor isolation that we enjoy in properly configured vSphere environments, as long as we don't exceed the reasonable thresholds for the 4 food groups, CPU, I/O, memory, and network, the noisy neighbor isolation is so good that there's no longer any need. Oh, yeah, customers the first few months when they go to Oracle on VMware, they may keep their pre-production and their production workloads separated. But a lot of those customers get bored with that separation after a while, and they allow things to float, thus surrendering what was necessary, a decade ago, and named user plus licensing being very common in pre-production environments. A lot of customers discover with Oracle and VMware they no longer have that need. So it's yet another form of consolidation of the hardware and especially the license environment that's very, very favorable.
Back to Dan Hesselink. Is there any differences here in what we've discussed if, say, for instance, we're not talking about VMware, we're talking about Hyper-V, or we're talking about KVM? Is there anything specific that applies to VMware, do you think?
No, not really. I mean, I think for governance purposes, it does have better controls, although you could improve your audit logs. To make them
I'll take that to note. I'll take that back.
But I think the governance features are very good for VMware. I mean, it prevents contractual incompliance in a great way. Other than that, I'm noticing people love it. I mean, I'm a licensing guy, right? I'm not a VMware or a Microsoft or whatever.
Dave, do you have any comments on that in regards to anything that's different, anything that would be different for a non-VMware virtualized environments?
Not really. The only thing that I would note is that Oracle grants a privilege OVM to do soft partitioning to restrict the number of cores that need to be licensed within a single physical server. The same privilege exists as we have demonstrated here on VMware. So yeah, in that environment, having proved that the contract is indeed agnostic to VMware, I really don't have anything to add. There's no delta.
Yeah. And honestly, I knew the answer to that question. It's been coming across, and that's the whole point, folks who are on the line. The contract is agnostic to VMware and other things as well. Dave, I have a couple of linguistic questions for you that are kind of interesting. First of all, on the contracts, I believe it was in around 2013 that the OSLA was replaced with the Oracle Master Agreement.
That's correct. About February of 2013 it happened.
Okay. Is there any substantial difference between those two?
None. For the 6 issues that we discussed today, there are none.
Right, this is one of my favorite questions. Dave, you and I both taught on a bunch of high school, and I think I taught high school and I taught in grade school as well in earlier life, and I think you did too. And we would never accept this sentence from or this definition from a student. So when Oracle defines the word processor as being where all processors are run or installed, they're defining the word processor with the word processor. Any way we can deal with that, you think?
Well, in this context, a processor, back before 2002, when we got into multi-core chips that were publicly available, commercially available, a processor was equivalent to a core. Then when multi-core chips came out in the early 2000s, that first decade, then we had to distinguish between a core and a processor. So as it relates to standard edition, the contract makes very clear that a processor is equal to a socket of a server. As it relates to everything else, Oracle has made very clear that a processor is factored through the Oracle Processor Core Factor Table, which is indeed contractual. Or for document, Oracle, as of July 2005, the URL is still out there on Oracle's website, introduced multi-core chip discounts. And in that document, which once again becomes an implied license, even though it's not part of the contract, it grants privilege to the license. It very clearly in that document distinguished between what used to be a processor and what is now a core, a multi-core chip. Hope I answered it, Don.
Yeah. Thanks, Dave. I'm going to throw this question out to first Daniel, then Dave Welsh, and then also Dan Young. I'm going to ask you to sort of weigh in on this as well. Daniel, and this is a very broad question, and it's a bit loaded. How does everything that we've talked about here relate to licensing Oracle in public clouds, particularly vCloud Air? Yeah, sorry, I know it's a big question.
Yeah, I mean, if I would, as a small company, rent one small virtualized virtual server, then Oracle would want me to license the entire data center behind that server, right? So that is the ridiculousness of all. Now, if my provider can prove that I'm only running on 2 cores and never more than on 2 cores, and they are, let's say, default Intel cores, who's going to tell me I'm in compliance? I mean, I'm innocent until guilty, right? At least in most of the countries, I am. So Oracle would have to, I think, Oracle would have to prove that I would be guilty, which they can't. I mean, I show them my contract. I say I'm running on 2 Intel cores at any given point in time, and not more. That's what I'm paying for. I'm not quite getting anything else. So
well Daniel, let me just stop you there for a second, just so you know, and I kind of set you up with this, but we at VMware with vCloud Air are right now offering the idea of a dedicated cloud, just specifically to be able to deal with these sort of boundary issues. So with that in mind, I'm sorry to interrupt you, but go ahead.
Well, it all stays the same, right? It doesn't really matter where I'm renting a cloud. The big question is, am I governing my deployment within the cloud? So if I'm not, I'm in a bad spot. Well, I'm I'm a step behind, really. And I want to be ahead of the game. So I want to be reassured that the cloud is governed in accordance with my terms and conditions. So if you guys are doing that with the vCloud, good for your clients.
Dave, well, can you follow up on that?
Forgive me, I'm going to need you to restate it. I was paying attention to a post that came in.
Well, I'm just asking a general, broad question, a little bit loaded about public cloud licensing and everything that we've talked about here.
Yeah, public cloud licensing really is nothing more than what we've got already, and that is the implied license that Oracle granted 5 years ago with the Oracle Cloud Licensing Policy document that allows workloads with limited core counts to float anywhere on any physical server, either within Amazon AWS EC2 or more recently in Microsoft SQL Azure environment. But other than that, the licensing is identical to the same privileges and restrictions that you would enjoy in your private cloud environment.
As Dan Hesselink was saying, you just have to be able to govern exactly where your Oracle software is running at any particular time. And as long as you know that definitively, you're fine, I guess, is the point.
That's correct, Don.
So, Dan Young, you at Indiana University, are you, and I don't know the answer to this, are you moving in any direction from a public cloud perspective, and is there going to be any Oracle within your strategic long-term public cloud?
Actually, from a strategic perspective, the answer there, at least in our particular case today, is no. We actually run a relatively large private cloud shop, and we have the facilities here to actually expand that cloud, and we're actually looking at offering some services to other institutions across the state as well. So actually, we're to a degree becoming one of the behemoths in the room when it comes to that. But we do deal with and have to answer the exact questions there when it pertains to our university Oracle license and how we run that inside our cloud versus running, say, having an outside entity leverage our license, which they're unable to do. But it comes down to the question oftentimes of, as they mentioned, how you're physically isolating those servers and clusters and trying to make sense of that. But
as Daniel said, how you govern the actual use of your Oracle in general, right?
Exactly. Where we put it, who we give access to it, to really help us to be able to define where is Oracle running at any given point in time, and that to me is just the critical piece of any of these contracts. That line that Dave pointed out earlier is just where it's running. Obviously, it can't be in two spots at one point in time. So that's where we leverage and lean on that quite a bit.
Okay. I think I've covered pretty much everything in regards to the important questions. Folks, there are a lot of other questions that are out there. We will respond to all the unique questions as much as reasonably possible. But for now, I think I need to turn it back to Stephen, and we'll finish up.
Fantastic. Thank you, Don. And I think we do have some slides coming up related to some assets that are available for people to learn more, as well as some IOUG opportunities. Did you want to cover those real quick?
I do. So first of all, there are a number of books from Pearson, VMware Press. The Virtualizing Oracle Database is on vSphere. Myself and Kanan Mani are the authors of that particular book. Chapter 7 is all about Oracle licensing and support. And we also have the sister book, which is a SQL Server book. I want to highlight a survey that was done by Database Trends that had magnificent quantitative data come out of it of the IUG membership in regards to the adoption rate of vSphere for Oracle and the acceleration of the adoption rate. There's some details down here, but the most important one is that you can access the survey on Database Trends site. Some of the more important numbers and quantitative results are, again, that the acceleration is tremendously increasing. We saw that somewhere around 57% of the IUG membership was actually virtualizing production systems, and over 60% of that were using vSphere, and that includes every possible virtualization technology that exists. We did see a very quantitative and clear result that the main restriction or the main hesitation was still the perception of licensing costs, the perception of increased costs. But then in other areas of the survey, we saw that the main benefit was the decrease in overall costs when you virtualize. So there's a serious contradiction there. So again, it goes back to the perception. And I'm hoping that this particular webinar is going a long way to actually clear up some of those misperceptions. As I mentioned before, Dan Young is the new president of the VMware Special Interest Group at IUG. There previously was a virtualization special interest group, but this is a VMware Special Interest Group. We will have a booth at the Collaborate Conference at Mandalay Bay in Las Vegas next month. The VMware will have a booth, and we will be offering a sign-up station for the VMware SIG, and it is a completely independent SIG. Nobody from VMware or EMC is on the board. They will be running themselves. Of course, we will try to support them in every way necessary or possible, but we congratulate IUG for having the foresight and the wisdom to do this. Wanted to list out Dave Welsh's blogs, as he mentioned before, House of Brick blogs. There will be a number of them coming. VMware is an audit risk. Is an Oracle audit risk paper, critical review, that's coming out relatively soon. And there's going to be some other information. Dave probably, in my opinion, has the most extensive and prominent and useful blog on these subjects in existence. So I would certainly admonish everybody to be aware of that and read it regularly. And I think that's it, Stephen. So
absolutely. Thank you, Don, and thank you, Dave, Daniel, and Dan Young as well for bringing light to this subject today. A few quick last-minute items. If you would like to review this presentation or send it to a colleague, please use the same URL that you used for today's live event. It will be archived for 90 days. Plus, you will receive an email tomorrow once the archive is posted. And if you would like a PDF of this presentation, you can click on the resource icon at the bottom of your console. As we stated earlier, just for participating in today's event, someone would win a $100 American Express gift card. And the winner today is Tim Clemens. Tim, we will be in touch via email so you can claim your prize. Thank you, everyone, for joining us today, and we hope to see you again soon.
Thank you, Stephen. Thank you, audience, and most importantly, thank you, House of Brick License Consulting and Indiana University.